Hello. Thank you for coming to our event, Administrative Law Judges. What do they do and how do I become one? My name is Misha Sukerman and I'm one of the co-chairs of the Asian American Bar Association's Public Law Committee. This event is a co-production of ABA's Public Law and Judiciary Committees along with the Administrative Law Judges Committee of the California and Asian Pacific American Judges Association. Before I introduce our moderator, I would like to note that this event is eligible for 1 hour of California General MCLE credit. Please sign in by clicking the link in the live chat. In the description, you will also find links to the written materials, an evaluation form, and the event registration form. ABA will send certificates of attendance to all registered attendees. If you have not yet registered, please do so on ABA's website at the link in the video description. Now it is my pleasure to introduce our moderator for today's event, Dorothy Chow Proudfoot. Since 2018, she has been an administrative law judge at the San Francisco Rent Board, where she presides over arbitration hearings in residential rent control cases and mediates landlord-tenant disputes. She's a double bear, earning both of her undergrad and law degrees from UC Berkeley, and worked in private practice before spending 16 years as a deputy district attorney in Marin County, where she specialized in gang violence and sexual assault offenses. Perhaps more impressive, though, is how involved Judge Chow Proudfoot is in various legal associations and training programs for law students. There's simply too much to list here, so I will refer you to her bio, which is available as part of the written materials for this event. Without further ado, I will pass the mic along to Judge Chow Proudfoot.
Thank you so much, Misha. Good evening, everyone. I am Dorothy Chow Proudfoot, Administrative Law Judge with the San Francisco Rent Board. I'm a sustaining member of ABA and the co-chair of the Administrative Law Judges Committee of the California Asian Pacific American Judges Association. In case you don't know about CAPAJA, we are an active organization of judicial officers, approximately 150 strong by this point, working together to promote justice in matters concerning the judiciary and Asian Pacific American Californians. We have a process for supporting judicial appointments in addition to our educational, mentorship, and scholarship programs. And you can find out more about us at capaja.org, CAPAJA.org. I am so pleased to serve as your moderator for this program today. You are about to hear from a truly accomplished panel of ALJs with over 80 years of judicial experience. As you would probably expect, any opinions expressed are the panelists' own and not the official statements of their respective agencies. Our judges have graciously agreed to stay on to answer questions after the program and even have a little after-party Zoom so that you can ask some more questions. So go ahead and text your family that you're going to be a little bit late for dinner tonight. Please take advantage of this great opportunity to type questions in the chat as we go along, and we'll try to answer as many as possible at the end of the program. I wanted to make a short pitch also to those of you who may not be members of ABA yet. ABA is a fantastic organization, which I first joined when I was in law school, amazingly. And since approximately 2003, I've had uninterrupted membership in one of what I would consider one of the best bar associations out there. So if you haven't already signed up for membership in ABA, I would really encourage it. It's really brought me a community of amazing, supportive practitioners and friends. So please do join ABA. So in the interest of time, let me blaze through short introductions of each panelist that really won't begin to do them justice, but please do go ahead and read their fuller bios that are included in the written materials. First, let me introduce to you Administrative Law Judge Susan Lee. Judge Lee has been a judge since 2003. After serving for 17 years at the California Unemployment Insurance Appeals Board, including a stint as acting presiding judge of its Oakland office, she transferred agencies and now sits as an administrative law judge at the California Public Utilities Commission. Judge Lee was the first administrative law judge I ever actually met. When I first discussed the idea of this panel with Alice Lou Jensen, the ABA Judiciary Committee co-chair, the first ALJ we both thought of was Judge Lee. Now let me move to Judge Kristen Rosie. Judge Rosie has been a judge since 2007. She serves as the Chief Administrative Law Judge for the California Department of Insurance. She's also a mental health hearing officer for the Alameda County Superior Court and a senior adjunct professor at Golden Gate University. Judge Rosie and I actually live about 5 minutes apart, away from each other, and we actually have a lot of common friends, but it took a National Association of Women Judges conference down in Los Angeles to finally meet each other in person. Next, let me turn to Chief Presiding Administrative Law Judge Susan Formaker. Judge Formaker has been a judge since 2008. She serves as the General Jurisdiction Division Chief Presiding Administrative Law Judge for the Office of Administrative Hearings for the state of California. She's been on the faculty of the National Judicial College, teaching other judges how to be judges since 2010. Judge Formaker and I actually served on the board of California Women Lawyers together, starting probably about a decade ago. She was the first judge I had ever served on a board with. And frankly, I owe all of my positive board meeting decorum to her impressive example. And finally, let's turn to Judge G. Judge Jennifer G has been a judge since 1982. That's right, 1982. Spending 11 years with the U.S. Merit Systems Protection Board, 6 years with the California State Bar Court, 2 years with the California Department of Insurance, and 1 year with the Office of Hearings and Appeals for the Social Security Administration before joining the Department of Labor in 2002, serving as its district chief judge from 2007 until her retirement in 2019. So she has both federal and state experience. She's been on the faculty of the National Judicial College since 1994. Judge G is a double bear like me, but I actually only recently learned that we have another thing in common. I was in the Cal Band in college, and she was on Rallycom. So we can discuss which was the best spirit organization later, but for now, go Bears. All right. Well, thank you all for serving as panelists tonight. I've done the bare minimum of identifying your positions and the agencies at which you've worked. So please tell us, what subject and types of matters does your agency handle? Let's start with Judge Lee.
Thank you. I want to thank Abba and Kapaja for having me on this very esteemed panel. I'm going to talk very fast so that my Chief Justice colleague is going to have time to speak about their work. So I work for 2 agencies now, California Unemployment Insurance Appeals Board for 17 years and California Public Utilities Commission now for 10 months. And the only thing that they have in common is their very, very long name. The 2 agencies couldn't be more different. So let me start with CUIB. When you talk about CUIB, it's probably the administrative law agency that you think of as administrative law. We do, or we did, I should say, I'm not there anymore, the appeals for the Employment Development Department. The Employment Development Department administers 2 programs. The Unemployment Insurance Program, which is all employer pay, and the State Disability Program, which is all employee pay. So a claimant either loses benefits or the employer is contesting the benefits, and that person will appeal to CUIB. A judge like myself will hear 30 cases a week, and it's full-on evidentiary hearing with witnesses, marking documents, swearing in, and taking testimony. So that's on the extreme end with regard to high volume and the nature of work. On the other hand, on the other spectrum, is the California Public Utilities Commission, and I am lucky if I do a hearing a month. So I really miss doing my hearings a month. I like to think of CPUC as sort of the perfect merge between the legislature and the judiciary branch, because we don't just do adjudication there. We do rate setting. We do quasi-legislation. Yes, we do adjudicatory. So some of the smaller cases that we hear would be a person who is unhappy with their PG&E bill and they're complaining about being overcharged, to, for example, my colleague just issued a $59 million fine against Uber for failing to provide us with the sexual assault information that we had requested. So the subject matter that we have at the CPUC are gas, electric, water acquisition, telecommunications, passenger regulation, and wildfire safety. So as you can imagine, it really, there's a huge difference in category there. We've been asked to speak about how it relates to state work. So I think that as CUIB, the volume probably most akin to commissioners in traffic court versus CPUC. There really is no akin in the state court because it's just so much legislative and rulemaking and public hearings and such. So my 3 minutes is up and I yield the floor.
Wonderful. I'm not going to police you that tightly, and please feel free to share the years of your wisdom with our audience here. Let's move next to Judge Rosie. Tell us about the Department of Insurance. What's that all about? I'm not familiar with the Department of Insurance.
Well, not surprisingly, the judges from the California Department of Insurance handle a variety of hearings under the California Insurance Code. Those hearings range from licensing matters to workers' compensation classification hearings, prior approval rate hearings, noncompliance, cease and desist types of matters. Overall, we have jurisdiction over about 45 different types of hearings under our statutes and regulations. Although we are housed within the California Department of Insurance, the Administrative Hearing Bureau, where the judges work, is physically and statutorily separate from the rest of CDI. And that is because the department actually appears in front of us quite frequently. And so we need to be physically separate from them for a variety of conflict of interest reasons. AHB itself, the judges do not report to the insurance commissioner. They are, again, housed separately outside of that, so that we don't have any contact with legal or the rate regulation branches. Our hearings are very similar to complex civil court proceedings. Pre-pandemic, of course, our hearings are held in one of our two courtrooms. We have one courtroom in Oakland and another one in Los Angeles. Both are outfitted the way you would see a traditional courtroom in Superior Court, with a raised dais. We have witness stands, court reporter area. Most of our hearings involve at least 3, sometimes up to 5 or 6 parties or interveners, and all of them are transcribed by a court reporter who's taking a verbatim transcript. In most instances, we allow pretrial discovery, and there's a great deal of motion work done before trial. So in that way, we are very much like a complex civil calendar. Overall, I would describe our workload as low volume and high complexity. Cases generally take anywhere from 6 months to 2 to 3 years to process. Our decisions are anywhere from 20 pages to maybe 250 pages. Because California is the largest insurance market in the United States and the 4th largest insurance market in the world, most of our cases, or many of our cases, I should say, are matters of first impression, and our decisions impact the insurance industry worldwide. So we really do have quite an impact, even as a small state agency.
Wow, that's pretty amazing. Let's turn from a small state agency to a big one with Judge Pulmaker. Tell us about the Office of Administrative Hearings.
So the Office of Administrative Hearings is actually the oldest central panel in the United States. What is a central panel, you might ask? That means that our group of ALJs is separated from the agencies for which we're doing hearings. What's special about a central panel? Well, there's something very special, and that's decisional independence. Our ALJs don't feel beholden to any of the agencies for which we're doing hearings. We have no fear of reprisals, and we don't feel any pressure to decide a case a certain way. And so the model of central panels is something that's been repeated across the United States, and we're very proud to have been the first. OAH has 2 divisions, the General Jurisdiction Division, of which I'm Division Chief, and the Special Education Division. The Special Education Division only hears special education cases, often appeals concerning the adequacy of special education services that have been offered by a school district. The General Jurisdiction Division, on the other hand, hears cases for over 1,500 different state and local agencies. The most common type of cases that the General Jurisdiction Division hears are licensing cases. And they typically involve cases where someone has either applied for a license and been denied, or has a license and is being disciplined based on some kind of wrongdoing. These are typically licenses to engage in a profession or a business. Everything from real estate to nursing, to physicians, to cosmetologists and barbers, childcare providers. It's a very, very, very broad jurisdiction. We also hear cases involving teachers who may be dismissed or where the school district is seeking to dismiss them. We also hear teacher reduction in force cases, cases where the Department of Developmental Services has either denied eligibility to someone who has sought eligibility based on developmental disabilities, or where there's a dispute about the services that are being offered by the Department of Developmental Services. We hear cases for the Department of Rehabilitation, disability retirement cases, many, many more. So OAH in the General Jurisdiction Division has this great breadth of subject matter. Our hearings are also similar in complexity to Superior Court or federal court trials. They're adversarial evidentiary hearings that can last hours to weeks. We have our hearings in administrative courtrooms in Sacramento, Oakland, LA, or San Diego, and we also do hearings off-site. Our procedures, however, are very different from Superior Court procedures because they're governed either by the Administrative Procedure Act or specific statutory and regulatory procedures for the particular agency. Generally, the evidentiary rules are more lax. There tends to be a lot less in the way of pre-hearing proceedings. Motions to dismiss and motions for summary judgment typically are not available. Many of our decisions are proposed decisions which are submitted to the agency for final review and adoption or non-adoption or remand back to OAH. Some of our decisions are final.
Wow, that is a lot. Is it true that the central panel actually will cover 1,500 different state agencies?
Yeah, no one judge is going to hit all those 1,500 state agencies or local agencies, but you have to have enormous flexibility as a general jurisdiction ALJ at OAH. You have to love to learn new things. If you like being really, really comfortable with one set of law, the General Jurisdiction Division is not going to be where you're comfortable.
Well, let me segue now to federal administrative law judges. Judge Gee, can you tell us about the Department of Labor? What sort of things does the Department of Labor handle?
Sure. The Department of Labor conducts hearings under over 80 different federal statutes. Our proceedings are more like a federal district court bench trial. They're full adversarial proceedings with discovery, motions to compel, motions in limine, everything that it runs the entire gamut. The types of hearings include workers' compensation cases under the Longshore and Harbor Workers' Compensation Act, which provides workers' comp benefits to longshoremen. But what's not known is that it also provides workers' comp benefits to every civilian employee on a military facility, all the Air Force bases and Navy facilities, and all civilian employees who are working for the federal government under contract overseas. So every single civilian worker in Iraq and Afghanistan who's killed or injured is covered by the Longshore and Harbor Workers' Compensation Act. And it's been interesting because there's, in the last 3 years or so, there's been a flood because it also covers foreign nationals who are employed as contractors. So our agency has gotten requests and appeals from people all over the world, Africa, the Far East, everywhere. We get a lot of cases under the Longshore Act. The other big chunk of cases are under the Black Lung Benefits Act, which are coal miners who are suffering from black lung disease. The two of them probably numbers-wise makes up maybe 40% of the work that's done. But fortunately, the settlement rate is fairly high in the Longshore Act. Another big chunk of our work is under the different whistleblower protection provisions of all the different. Every time Congress passes a law that has a whistleblower protection provision, they assign the responsibility for hearing the case to the Department of Labor. And then covers all the environmental statutes, Clean Air Act, Clean Water Act, Solid Waste Disposal Act, all the transportation industry, airlines, trucking industry, railroad. And those cases are not as numerous as the workers' comp or the black lung, but they take up a lot of time. They're adversarial, they're between private parties, and the hearings could last anywhere from 2 days to a whole month. Another area that we cover are the traditional labor laws, the Child Labor Act, the Fair Labor Standards Act, all the traditional federal labor laws that get enforced. And also H-1B, the H-1B workers, immigration workers. We also cover cases involving employers who are alleged to have violated the discrimination provisions of the federal contract under the federal contract laws. Our hearings last anywhere from half an hour, or not half an hour, but half a day to, as I said, 4 weeks or a month. The decisions will range from 25 pages perhaps to a couple of hundred. The San Francisco office covers the entire Western United States. So somebody who works in this office has to be willing to travel. The judges tended to be traveling at least 1 week a month, if not more. And our hearings are held in our courtroom in San Francisco. We have a courtroom in Long Beach in Southern California. Otherwise, we borrow the federal district court in the different cities that we go to. We have an arrangement with the tax court and the bankruptcy court. And we've also used state courtrooms when we've not been able to find a federal district court. I used to use the Ninth Circuit Court of Appeals in Seattle a lot. But the number of parties ranges from 2, where it's just a simple workers' comp case under the Longshore Act, though under the provisions of the law, I had one Longshore case that had 40 parties because the person had worked for, there was an asbestos claim and a welding fumes claim, and the claimant's attorney had named every single employer the person had ever worked for, along with every insurance carrier that had ever insured the employer.
Wow. And it's a fire hose of information.
It was. I wound up, my first status conference, I had 12 attorneys in person in the courtroom, and I forgot how many on the phone. It was a zoo.
And speaking of the phone, if that's someone's alarm about time, that's great. If it's someone's phone, please put it on silent.
Sorry, that was mine. It wasn't ringing before this sun started.
All right. So let me actually take a pause right now. And Judge G, I do want to say for you particularly, because you've worked at so many different agencies, I'm sure that there are a lot of questions that people might have about individual agencies. And we encourage people to chat with you afterwards about some of those. So let me actually move to another kind of a two-part question. What is the type of work that the ALJs at your agency do? And what is the number one thing you think attorneys who practice before your ALJs need to do or learn in order to be successful advocates in your fora? And let's start with Judge Formaker. Oh, you're on mute.
Thank you. The primary work of ALJs at OAH is to conduct evidentiary hearings on behalf of agencies, as I discussed before, and those can last for hours or weeks, and then to write proposed or final decisions. Those decisions can be quite short in relatively simple cases, as short as 5 to 10 pages, or very long, like over 100 pages in very complex cases. An ALJ may be conducting hearings at the same time that the ALJ is writing decisions. And in general jurisdiction, the time deadlines for decisions can also vary widely, from 10 working days to 30 calendar days after a case is submitted. So time management skills are really critical to being a successful ALJ. A successful ALJ needs to be an efficient, excellent writer with superior analytical skills and the ability to learn new areas of law quickly. A successful ALJ also needs to be able to preside over hearings in a way that demonstrates neutrality and a lack of bias. And an ALJ has to have the ability to maintain an excellent judicial demeanor and to treat everyone with respect and dignity, even if the parties appearing before the ALJ do not demonstrate appropriate behavior. I know that's a surprise. An ALJ at OAH needs to be adaptable. You may have last-minute changes to the calendar. You may need to travel on short notice. You need to be able to deal with constructive criticism. All of our decisions are subject to 1 to 2 levels of internal review. You also need to be able to conduct mediations and settlement conferences. So good people skills and emotional intelligence and the ability to communicate effectively are essential. In terms of attorneys, to be successful in appearing before OAH, you should know the rules of the road. First of all, the Code of Civil Procedure does not typically apply to our proceedings, so you need to become familiar with the Administrative Procedure Act and any statutes or regulations or ordinances that will apply to a hearing before the particular agency that the hearing is before. And you need to follow those rules. So be prepared, do your homework, learn the rules, and be on time.
Excellent. That's actually great advice in appearing before any tribunal. What about in federal court or federal administrative law judge proceedings? Judge G?
Well, everything that Judge Formaker said for ALJs applies before the Department of Labor and all federal ALJs as well. For the Department of Labor, the judges conduct hearings. They do all the pretrial stuff. They're ruling on motions to compel. They conduct status conferences to check on the parties to keep the cases moving. They also conduct settlement conferences. We had a procedure in San Francisco under which a judge who's not assigned to hear the case could conduct a settlement conference with the parties to try to get them to resolve the case. And then the judge will review and approve settlement agreements. They do write decisions, and as I mentioned earlier, the decisions could be anywhere from 25 pages to 100 and some odd pages. Because there are so many different federal statutes, the judges have to be familiar with the statute that they're going to be they're conducting the hearing under. And that varies because, for instance, under some statutes, we have subpoena authority, and other statutes we do not. And the federal rules of evidence apply to some, but not to others. And then there are also some statutes that require that the case be decided the hearing has to be held within 10 days after it's received, and the decision within 10 days because of the urgency of the matter. So it becomes really tricky, and it's a challenge. Because there's travel involved, the judge has to be able to adapt to whatever the new environment they may find themselves in. Let's see. I do want to say, though, that there are probably 90% of the federal ALJs work for the Social Security Administration, and their jobs are totally different. They're non-adversarial. They're much more like the COIAB work that Judge Lee mentioned. And they actually have a production, I won't say requirement, but that's their target, is that they're supposed to hear and decide 700 cases a year. And there's no such thing as settlement in Social Security cases. So their work is very different. The work for ALJs with the federal government varies from agency to agency. So if anyone's interested, they need to find out what that particular agency's judges do in terms of work, because the scope of the work and responsibilities varies. The OALJ, or Department of Labor, has the broadest spectrum of responsibilities. As for what attorneys need to know, what Judge Formaker said applies, but they need to be prepared. We have rules of procedure, and they need to be aware of those. They need to read them and know what they are and comply with them, because we have specific rules about filing. For instance, motions cannot be filed unless they first meet and confer with the other party. Not all rules of procedure require that. And they do need to be familiar with the federal rules of evidence if that's going to apply to our cases. But the most important thing is, especially for our whistleblower cases, they need to be flexible when we're dealing with a self-represented litigant, which we do see a lot of. And that's a skill that, unfortunately, a lot of attorneys don't seem to have. And it becomes the judge's responsibility to make sure that the self-represented litigant getting an adequate hearing before the judge.
No, that's very, very true. Judge Lee, let me ask you a little bit more about same question for the agencies you've worked for.
Okay, so unlike OAH, we, the CPUC, Public Utility Commission, is not part of the APA, so we are not governed by them. Practitioners do have to know, of course, the Public Utilities Code, and you have to know a lot of legislation, because when we do the quasi-legislative work, you have to understand how this proceeding may impact legislation that's either coming down the pipeline, has come down the pipeline, or even affect something in the future. So every proceeding that an ALJ is assigned, you are also paired with a commissioner, except for citation appeals. So let me just at a high level explain that very quickly. At the CPUC, we are a mini legislature. We have 5 commissioners who are all appointed by the governor in staggered terms. And when you have a proceeding, you are really running a proposed decision for that commissioner. So you need to work very collaboratively with that commissioner advisor. You need to understand where the direction is that the commissioner wants to go, because your goal is to have your decision voted out when it goes to a commission meeting, and the commission meets once or twice a month. So a typical case for me that's a large proceeding would be, you would have an advisor, you would have the energy person, whether it's gas or electric, and then I would also have an advisory attorney. So it's really just a teamwork in getting this decision out. And I just mailed out today the San Diego Gas and Electric general rate case. So all the large utilities have to come to the PUC to get the okay from us to charge us the rates that they charge. And that is what that is a regulatory proceeding as to what the PUC does. As far as what practitioners need to know, I think in any situation, I agree with Judge Formaker and Judge G, you have to know the rules of evidence. But now, particularly in COVID, what may have applied pre-COVID does not apply during COVID. So we almost do not accept any hard copy filings, but service does not mean filing, and filing does not mean service. So you have to make sure that you know the rules in and out. And we are, a little bit forgiving, because we understand that we are in COVID, versus that the Unemployment Insurance Appeals Board, because of EDD's antiquated system, they are not even electronic. They still have manila folders. And because of security reasons, CUIB does not accept electronic evidence. So everything is by fax. So you've got to know your agency, you have to know the rules, and you have to know the rules that govern how you get your evidence in before the judge.
Wow, that's my own agency. We just got rid of our fax machine during COVID. It was the perfect excuse to get rid of it. But yes, that's quite amazing. Let me ask Judge Rosie, anything to add about your agency that's any different from the other agencies?
I think we're not that much different than Judge Formaker at OAH. Our proceedings are adversarial. As a judge here, you're usually doing pre-hearing case management, whether that's status conferences or motion work. You're conducting a hearing or your decision writing. And frequently, as Judge Formaker indicated, you're doing all of those things on different cases at the same time. And so you need to be, on top of things. You need to be good at managing more than one task at a time. And so in that way, we're very similar. And I don't know that I have a lot to add on procedure, but I will say, as far as successful strategies for attorneys, I would echo what Judge Formaker said about the APA. You need to know the agency's own regulations, and you need to know the APA if it's covered, if the agency you're appearing in front of is covered by the APA. And specifically, I would say you need to know that the APA, for example, permits some hearsay evidence. And so making it a hearsay objection repeatedly in a hearing makes the judge think that perhaps you haven't read the rules. And so I would caution folks to make sure that they do read the APA. The other thing I would say is that sometimes attorneys forget that there's no jury in the courtroom and that you're appearing in front of a judge and it's a bench trial. Even though it's an adversarial evidentiary hearing, it's a bench trial. And so some of the more theatrical presentations are not necessary in administrative proceedings. You're talking to you're talking to an expert in both the evidence and in the subject matter that you are litigating. So what you have in front of you is really an expert, and you don't need to the hyperbole that sometimes comes with those kinds of presentations. So that's what I would say as strategies go.
Some words of wisdom indeed. So let me segue now to asking you each, let's get a little more personal. What was your path to the administrative bench? Judge Lee?
Well, my path was very personal. My first experience with an administrative law judge was actually as a claimant. I had a disability appeal with the State Disability Office from the EDD. I was denied, and I appeared in front of an ALJ, and that presiding judge would end up interviewing me, and 8 months later, I became an ALJ. But the really interesting thing that I want to point out is, even at the time when I appeared in front of him, I was an attorney at the time with the East Bay Community Law Center, doing tenants' rights work, doing litigation. We pushed everything to jury trial, very intense job. Even at the time when I appeared in front of an ALJ, I didn't even think about becoming an ALJ because I was stuck on this notion that I really had to know the subject matter. I didn't know anything about unemployment insurance, but who practices unemployment insurance? Nobody practices unemployment insurance. You practice employment law, right? And I didn't do any disability, so there was just no, it was not in my mind at all to become an ALJ until I had a back injury, which caused the surgery, which caused the disability appeal. And I had lunch with a mentor and said, I don't think I can do this litigation anymore. What do you recommend I do? And he said, well, why don't you become an ALJ? And I said, what's that? And he said, an administrative law judge. I said, oh, that's a great idea. So the rest is history. And, this is my 18th year and I love it. And it's the best kept secret. The state ALJ job is really a great, fantastic place to be. You get the work-life balance and stick with it long enough and you get a pension at the end, a great pension at the end.
Oh, that's very key. Let me ask you, Judge Rosie, what about your path to the bench? Was it anything like Judge Lee's?
It was similar, although I'll echo the pension part. So like one of the other panelists that you'll hear from, I am a career state public servant. I went straight out of law school and spent my first 12 years as an attorney in state administrative agency doing reviewing unfair labor practice complaints for public sector employees. I was fortunate enough there to get a lot of brief writing experience, a lot of decision writing experience, was able to appear in front of the Court of Appeal and California Supreme Court representing our agency, and then got to do a lot of settlement conferences and even do some hearings, representation hearings. And so I knew a lot about ALJs. Our agency, the agency I was working for, had them. So I knew what kind of work they did already. When it was clear after a political shift at our agency that I would not likely be hired as an ALJ, and I had reached sort of the top of the attorney ladder at that agency, I started looking at other state agencies for ALJ jobs. I actually applied at CUIAB, unemployment insurance, and at the California Department of Insurance, and ended up taking a job at CDI. So I was this close to working with Judge Lee at CUIAB, and I missed that opportunity, but we're here together today. So it all worked out. I will add something to what Judge Lee said, and that is that I knew absolutely nothing about insurance law when I became a judge at CDI. And I famously tell the story, and so some of you have already heard the story, but I was asked actually during the interview what I knew about insurance law, and what I responded by saying was that I knew I had to have insurance to drive a car. And that was pretty much all I knew about insurance. So shockingly, you know, I got hired even with that response, but I didn't know anything about insurance law. And I say that because I think it's really important for folks to hear that you can become an expert in areas of law that you know nothing about. And if you had asked me 13 years ago, when I first became a judge, if I would become an expert in insurance law, I would have laughed. But it turns out you can be, and you can learn the area of law. And learning the area of law turns out to be a lot easier than learning to be a good judge. That takes a lot longer. So that's my path.
All right, let me ask Judge Formaker. How about your path? Were you in public, private? Where did you come from?
So I came from the private arena. And I had been in private practice as a litigator, primarily business litigation and some family law. And then for almost 20 years, I was a litigator for financial institutions. And so I did all kinds of cases involving financial institutions, as well as internal investigations. And it was both plaintiff and defense work. So it was everything from lender liability cases, cases involving embezzlements, cases between banks on embezzlements, on who would be left holding the bag, as it were, and class actions, all different kinds of issues involving financial institutions. And starting in about 2007, I started thinking about what I wanted to do with the rest of my legal career. And I was on the board of California Women Lawyers, I still am. And on a plane ride to the Bay Area for a meeting, I was sitting next to Diane Tan, who told me all about being an administrative law judge. And so I started researching different administrative law judge positions, both at the federal and state level, and happened upon OAH. And it just sounded so interesting to me. And I learned as much as I could about it and applied. Before my first interview, I read the entire Administrative Procedure Act twice. Because I had never done an administrative proceeding before OAH. So I wanted to learn the rules of the road. You know, I started as an ALJ in 2008. By 2011, I was presiding ALJ of the Los Angeles office. And as of the end of October of 2020, I'm the division chief over the General Jurisdiction Division.
Wow, what a great story. It's amazing the things that the past that we can go based upon conversations in airports. So let's talk about airports, Judge G.
Okay.
How do airports play into your career path? And
it has been long. It probably started before most of the people participating were born. But I'm the other judge who spent her life in public service. I started working for the Equal Employment Opportunity Commission after my first year of law school. And then I was hired by them again after my second year. And at the end of that summer, they asked me if I would be willing to work for them on a part-time basis during my third year. And when I hesitated, they said if I took the job, they would just hire me as a trial attorney right out of law school. So needless to say, it was an offer I couldn't refuse. So I litigated employment discrimination cases there for about 8 years. And at the end of 8 years, President Reagan fired 12,000 air traffic controllers. And the Merit Systems Protection Board hears appeals from federal employees regarding personnel issues, and they were hiring. So I thought it'd be a change, it'd be interesting. It might be narrow. Like everybody else, I knew nothing about MSPB law or federal personnel law, but I applied and was hired. And then from there, after 8 years there, the the California legislature created the California State Bar Court, and they were looking for applicants. And my chief judge at the time encouraged me to apply, saying, you know, it's a great opportunity. And I said, but it's a 6-year term. What happens at the end of 6 years? And said, well, you can come back here. Mm-hmm. So I applied, got appointed by the California Supreme Court, but at the end of 6 years, there were no vacancies at MSPB, which is how I wound up at the California Department of Insurance, but before Kristen got there. But meanwhile, because of the uncertainty with MSPB, I had applied to become a federal ALJ. And that application process at the time was lengthy. The application itself was very similar to the application that somebody has to fill out if they want to become a California Superior Court judge. It was that lengthy. And the application process involved a long application, a written examination, and an oral examination that was administered by the Office of Personnel Management. And you got a score for your application, the written exam, and the oral exam. And then the OPM would use a formula to assign each applicant a score. And then when a federal agency needed an ALJ, they would go to OPM. OPM would start at the top of the list with the highest score and refer people out based on their score. The catch for most women, and maybe probably a fair number of minorities, was that veterans got a 5 or 10 point added to their score. So if you were a non-vet, the maximum score you could get was 100, whereas a veteran could get 110. And OPM was sending out people based on their scores. So for the longest time, until more minorities and women got into the military, the ALJ Corps for the federal government was all white male. And even the class that I went to, there were 130 people in my ALJ class with Social Security. And I think there were 20 women. I was the only Asian, which made it was hard to not stand out, let's put it that way. But in 2018, the California Supreme Court issued a decision finding that administrative law judges are inferior officers of the U.S. government, and they had to be appointed by either the president or the department head, which meant the Secretary of Labor, Secretary of Energy, or whatever the appropriate agency was. And following that, President Trump issued an executive order which abolished the OPM selection process and made the only requirement to become an ALJ that you be a member of the bar. But each agency now can hire on its own. They set their own criteria, and included in the materials is a fact sheet put out by OPM about the hiring process and the salaries and everything else. And I also put together a sheet that explains the difference between an administrative judge, which is what I was with the Merit Systems Protection Board, and an administrative law judge.
Thanks so much for preparing those materials. We're going to segue over to how to become an administrative law judge. But before we do that, I just wanted to give our panelists a brief moment to talk about, assuming that most attorneys don't regularly practice before an ALJ. I certainly never had before I became an ALJ. What are some things every attorney should know about ALJs and their role in the legal system? Let me ask Judge Rozzi to start on that.
That's a great question. What I would say is, first of all, that there are a lot more ALJs out there than you think. And Judge D alluded to this, but there are more judges at Social Security, for example, than there are all Article III judges combined nationwide. So there are a lot more ALJ jobs out there than you think. The other thing that I think is really important is that that we recognize that most people's experience in front of a judge, and maybe their only experience in their lifetime, will be very similar, assuming they're not attorneys, of course, is going to be very similar to what Judge Lee said, and that is that you're going to end up appearing in front of administrative law judges. If it's a benefits denial issue, unemployment, disability, if it's special education and you have a child who needs special education issue, if you're a teacher and you've been laid off, the people that you are going to be appearing in front of in your lifetime will most likely be ALJs. And so it's important that you understand what ALJs do, where they come from. And I would also say that those facts make it crucially important that the ALJ judiciary be as diverse as the community that it represents. Because again, these are the folks you're going to be appearing in front of more often than not. And so a diverse administrative judiciary is vitally important.
That's a great point. I mean, we become the face of the legal system for most people. Judge Formaker, do you have anything to add about particularly the OAH's role in the legal system? And you're still on mute.
I'm sorry. Particularly with respect to the licensing hearings that the General Jurisdiction Division does, I think it's really important for the public to understand that the critical role that we have in protecting the public from dangerous practitioners, but also ensuring due process and ensuring that agencies don't overreach. It helps to balance the power of agencies while still protecting the public.
Let me ask Judge Lee, do you have anything to add to that?
On the unemployment insurance appeals side, because that agency does so many appeals per week, just to think about what would happen to Superior Court if all those cases had to go to Superior Court. So the CUIB definitely provides that cushion so that the judiciary doesn't get overburdened with these smaller cases, with these administrative cases. And on the CPUC side, it is not unusual for us to have a public participation hearing on, let's say, electrical vehicle grid electrification, where we would have 500 people up and down the state, coming to give us comment on why it should or they shouldn't have an electric vehicle charging station in their neighborhood. So we definitely serve the public, and we provide a service that the judiciary and the legislature cannot provide, or we are a complement to them.
No, that's a great point there. And I'm trying to be mindful of the time as well. So, we're not going to get very granular about how to become an ALJ. Obviously, there are many different procedures. And just like with appearing before ALJs, you need to do your homework. But let me just ask our panelists to take sort of a little broad summary, or any helpful tips that folks should keep in mind when they think about this. And let's go to Judge Formaker to start that. And you're on mute.
I'm really good at that. So we provided some materials that give guidance on the state process for applying for an administrative law judge, which follows generally the state process for applying for any job. So you need to go on to the CalCareers website and take an online exam in order to qualify to apply. So if you are reachable, that is, if you score high enough on the online exam, then you can submit an application, and that will be the state's form application that has you list all of your experience, or at least experience going back, I believe it's 10 years. And then you submit it online through the CalCareers website with whatever additional documents are required by the agency to which you're applying. At OAH, we also require a resume and a writing sample. If you're then chosen for an interview in the General Jurisdiction Division, we do a timed writing exercise, and there are a set of open-ended questions asked of all the candidates. Then the most successful of the candidates are asked back for a second interview with the executive team and they're also given open-ended questions, and each candidate is given the same set of open-ended questions. Then there are calls made to supervisors and other references, and a review if you are coming from state service of the official personnel file. If you're coming in from outside state service, recognize that you're going to be coming in at the lowest level of ALJ1. So it may be a significant pay cut. It was for me, and it was worth it. And then once you're hired, you've got a 1-year probationary period with a lot of training, and you're assigned to a mentor or a series of mentors who will review all of your work.
Yeah, no, that's that takes a fair amount of work and a lot of effort on that. And let me ask Judge G. You had already alluded to the fact that the process for federal ALJs is as complicated as a Superior Court application.
It used to be. It's not anymore.
Yes. But let me ask you then about this point that Judge Formaker just mentioned, mentoring. Are there ways to actually get mentorship to become an ALJ?
Probably if you know somebody. I know that the National Judicial College has a mentorship program because I was asked to mentor somebody. Actually, I just spent an hour on the phone with him today because he wants to become a federal ALJ. And I did not know the program existed until I was asked to become a mentor. But the Judicial College might be a good resource. Other than that, it's word of mouth. It's my networking. I got my job with the Department of Labor because when I became an ALJ, a friend of mine was already an ALJ there, and she told the chief judge that since I'd just become an ALJ, I was somebody he should grab at the first opportunity. And a friend of mine, well, I shouldn't say, well, the staff attorney who worked for me at the Department of Labor is now an administrative judge with the Merit Systems Protection Board. And he got that job because I called my friends over there and said, you know, are you guys going to be hiring? And when you do hire, let me know. And I passed the information on to my law clerk, staff attorney, and he applied, and he's now an administrative judge with the MSPB. So a lot of his networking, knowing people, and just getting the word around. Now the hiring process for federal ALJs is through USA Jobs, but as the fact sheet for OPM indicates, agencies are not required to advertise the vacancy for an ALJ position. Yes, they could just hire, the Secretary of Defense or Secretary of Labor could decide, oh, my pal who's got a daughter who's an attorney wants to become an ALJ. Okay, they got a job. There are no criteria now, unless the agency sets it.
That is, that's probably going to be a future discussion about things like qualifications for federal ALJs, but it does really highlight that it's important to get to know people who already do the job. And really that's one of the reasons that we're having this panel, to put that information out there. So it's not only the country club golfing buddy who gets to hear about the opportunity. It's really about an effort to make sure that that information is out there for all qualified applicants, particularly diverse applicants who can really represent the communities that we are serving.
I think one important thing is to hone their writing skills, because the judges who are in the San Francisco office right now are all judges that I hired while I was district chief. And one of the key things is their writing ability, because we're writing very long decisions that can wind up before the Ninth Circuit Court of Appeals and potentially the Supreme Court as well. And so they need to be very analytical, very detailed, and very well written. And that was one of the criteria I used when I was hiring judges for my office, because it's such an integral part of the work, besides conducting the hearing and being able to act expeditiously when you get a motion.
Right. Let me ask Judge Lee. Judge Formaker's already laid out the process at OAH, and my understanding is that in some of the other agencies it's similar. Is there any difference about eligibility for jobs with your agency?
At the Public Utilities Commission, it's very, very different. So half of our ALJs are non-attorneys. Now, how does that happen? Because the work that we do is so technical that if you are an economist or an engineer or a statistician or a mathematician, we want you. And it is not uncommon for the large proceedings where the legal ALJ with no utility background, no energy background, will be paired with the non-lawyer ALJ with the utility background, and the two of you as a team will go through the proceeding together. You will run the hearing, you'll write the decision, and our decisions are very long also. In fact, Judge G, I'm being sent to NJC writing school in September. I'm still on probation at my job. I do think that it's important to understand that there are minimum qualifications that you have to be. There's a bare minimum state qualification. So go on the calhr.ca.gov website first to see if you meet the minimum qualifications, because unlike OAH, CPUC actually does hire ALJ2s from the private sector. If you got that energy experience with the legal background, like we'd love to have a PG&E attorney, be an ALJ at our agency. Then when you see whether or not you qualify for an ALJ1 or an ALJ2, then you can go on the CalCareers, see what exam is open, and then take the exam. So you have to get on a list, as Judge Formaker said, and you have to rank within the top 3 rankings to be eligible for an interview. And typically, the exams are not supposed to be subject matter oriented, because theoretically, the agencies are supposed to share the list. So theoretically, if you get on an ALJ1 list for OAH should be sharing the list with DOI, or CDI, excuse me. So anyway, see if you qualify, take the exam, and then start looking at, what you might want to do. And the great thing about being an ALJ is the state of California is your employer. You can go anywhere you want. If one job doesn't work out and you think you might want to try something different, you can hop around. I know the chiefs don't want to hear me say that, but it's a great place to be, and we need more people of color, more women. When I left the Unemployment Insurance Appeals Board, 9 of the 12 presiding administrative law judges were white males. So we really, really need to diversify some of these agencies. CPUC has a very nice diversity. Some other agencies, need to work on it. So I think one of the questions was, does the state have any sort of policy on that? And the state does not have a diversity hiring policy that I know of.
Yeah, and so that's I think that's why it's so important that all of us in this community make an effort to reach out to folks, and particularly for CPUC, if you have friends who are engineers, have them consider that too. So I'm about to ask my last question of our formal session before we break into our question and answer. So I'm going to take this moment to encourage all of our audience members. If you have a question, go ahead and throw it in the chat, and we're going to try to go ahead and answer as many questions as we can for you. Also, if you haven't already done so, please sign in to this event by clicking the link in the live chat for MCLE credit. If you have not registered, you somehow found your way to this YouTube stream without registering through the Asian American Bar Association's website, please go ahead to AABA's website at the link in the video description and register for the event. That will also give you some access to being able to get more information about ALJs and these various processes we've talked about. So what I'm going to do now, my last question at this last question in the formal session here is, it's really the why are we doing this? I had phrased the question initially as, in a nutshell, why would you even want to give up the practice of law to become an ALJ? But really what this question is why is this the best gig? Let me ask Judge Rosie, start with you.
Judge Lee said earlier, this is the best job in state service, and until this panel, it remained a secret that it was the best job in state service, and now everyone's going to know, which is great for Judge Formaker and I, who are constantly trying to hire folks. It is the best job in state service. It's intellectually challenging. The work varies all the time, and it is true work-life balance, not pretend work-life balance, true work-life balance. And if you stick around long enough, you get a lovely pension out of it. So That's my 2 cents on it. And you might have to take a pay cut, but it makes up in other ways.
Okay, let's go to our other state chief, Judge Formaker.
So I echoing a lot of what Judge Rossi said. It's challenging, it's endlessly interesting, and it's really important work. I mean, you feel like you are really doing something that's vital to the public. Being a public servant is incredibly rewarding, and being an ALJ is just so very, very interesting. And you get to do a lot of writing, but without being an advocate for anything other than the right result. And you have both interactive portions of the job, conducting hearings, mediation, settlement conferences, and more solitary portions of the job, like writing decisions and orders. You get to ensure due process while protecting the public, and you don't have to answer or propound form interrogatories.
those dreaded form interrogatories to be avoided. So let me ask our other chief, Judge G.
You're never going to get rich as an ALJ. You can probably make a lot more money in private practice. But the big thing is that there is a work-life balance, because instead of when I was a trial attorney, having to deal with a pretrial deadline that was set by a judge, I set the deadlines and I set the things to fit. And it was great for me when my kids were young, because I would schedule the status conferences and hearings around my kids' schedule. There are some times when, like if I had a hearing scheduled and some emergency came up, I might not be able to take it. But the bulk of the time, I was able to schedule things around my children's things. And that work-life balance just was wonderful. And the other thing that's rewarding about being a judge is that you help people to resolve their differences, and you get them to bring closure and to move on with their lives. And that makes a huge difference. It's a really good feeling. There is a downside, and that is that sometimes the case law doesn't go with what you really like, but you're bound by the case law, so you have to issue a decision that you may not particularly like, and just hope that I just hope that I put enough stuff in the decision so that the losing party will file an appeal and the appellate body will agree with me, or agree that the outcome was wrong and go with the reasoning that I've kind of hinted at.
That's actually a really great point. This is when you're thinking about making a difference in the world and having your career make a difference. I call it the Ruth Bader Ginsburg dissent theory. Look up the Ledbetter case, and then look up her dissent, and then look up the subsequent legislation. And that's a great lesson for anybody working in governmental service. So Judge Lee, why don't you wrap us up on this issue? Why is this the best job?
Well, I'd have to echo what the other lady said, and that is there's just a fantastic work-life balance. I remember when I was a litigator at the East Bay Community Law Center, and my daughter was in preschool, I almost missed her Halloween parade because I was doing something that had a deadline. Versus when I became an ALJ, I never missed a soccer game. I never missed a cupcake bake, because you basically are in charge of your own calendar. And coming from a legal services background, I dealt with a lot of pro pers, and I also speak fluent Cantonese. So it's really important, I think, for people who appear in front of you to be able to relate to you. And having pro pers as clients really helped me to learn to be patient with the pro pers that appear in front of me. And 80% of the caseload at COIB is pro pers. There's a smaller percentage, in PUC, but there are self-represented litigants also. So whether, I'm making a difference one person at a time at COIB or rendering a decision that is going to affect millions of people, I know that I'm making a difference. And it really, it's the best mommy and daddy job.
So the issue of self-represented litigants, certainly in my agency, we frequently have proceedings with an attorney on one side or an attorney on no sides.
Right.
And so what is one thing that you've learned since becoming a judge that you wish that you had learned earlier about dealing with parties, about opposing counsel, about sort of managing cases? What's one thing that you have learned in your years of experience that you wish you had learned a little earlier?
Well, I think it's really important to recognize that just because someone has an ESQ after their name, it doesn't mean that they can more effectively present a case. You know, I have been so impressed by the ability of some self-represented litigants to present a cogent, effective, succinct case. And I don't think that any attorney should underestimate the power of a self-represented litigant to do a great job.
I agree wholeheartedly. I've had some self-represented litigants who did a better job than the attorneys. And I've also had attorneys who, parties who've won despite their attorney. And then I really did not feel right awarding the attorney fees to the attorney, because if the case had been based on the attorney's performance, the client would have lost.
Okay. So looking at the time now, what I'm going to do is I'm going to ask you each for just a one-sentence closing thought. And then we'll take a short break and then head into the Zoom room for some informal discussion. But before we get to those, yes, so let me ask you, let's start with Judge G.
Oh, great. I've really enjoyed my career as a judge because they gave me the work-life balance that I wanted. And I've had difficult decisions to make, but being a judge also has given me the authority or to sometimes work something out with the parties, even when the result may have been not favorable. I was telling my mentee earlier today that I had a case in which I issued the decision involving the Department of the Navy, and I wrote the decision. I called the Navy and I said, legally, you won the case, but morally, what you did to this employee was wrong. And they settled the case. I did not have to issue my decision, and I could not have done that if I had not been the judge. And that just gave me such a good feeling.
Wow. Judge Lee.
Well, I've been in public service almost my entire life. My first job was a field representative for former Assemblyman Elihu Harris in Oakland, Emeryville, and Alameda. And I'd have to say that this, by far, is the most rewarding job that I've had, because I know that I am really making a difference in people's lives every day. My decisions are going to impact somebody, so it's rewarding. It's challenging. There's never really a dull moment. And you really, really do have that work-life balance. So yes, you're not going to get rich unless you're doing something unethical, which I hope you don't. As an ALJ, but I really think the lesser pay is worth the quality of life that you will have. Okay,
Judge Formaker.
I loved being an advocate. I love being an ALJ more. It's just, as Judge Lee said, it is so incredibly rewarding. We're doing important work that matters, that changes people's lives. And we also have a great group of people at OAH who support each other, make each other laugh, which has been so important over the last 15 months. So, I just encourage everyone to apply. And if you don't get it the first time, try again.
Wise words. And let's have you wrap it up, Judge Rosie.
Thanks. I would echo what everybody else said, but what I want to say is that it is the best job in state service, but also you will meet some incredible other judges, and the four of you are an example of that. And there are all these opportunities to be involved with other judicial organizations and to make a difference in those organizations as well. And you tend to find that your friends all become judges. and you start hanging out with a big judge group. But I will say that the judges that I am friends with are some of the most brilliant and wise and compassionate, dedicated people that I know. And like Judge Formaker said, you become this little family of judges, and it's especially during the last 16 or 17 months, we have needed that, even if it was only by Zoom. So in addition to the work, it's the people.
Yeah, we're lots of fun. We're a fun bunch.
Well, thank you so much. On behalf of Kapaja and ABBA, I'd like to thank Judges Lee, Rosie, Formaker, and G for a wonderful discussion we've had this evening. Thank you to the audience for your kind attention. Please spread the word that being an ALJ is the best job out there. And thank you, and good night.